Hi guys, it's Kathy. I hope you're doing well. We made it to Tuesday. Yep. Yep, most of us work today. It's okay. I mean, there are really just two things I could say to my tables when I'm serving. Two things that would make my day go better and their day go better. But I'm not allowed to say these two things to my table. Shut up and sit down. Those two, if I could just say those two phrases when I'm serving, everybody's day would be much better, including the table. Because if they just shut up and listen, if they just sit down first. But you know what? You know what I can say to my chat? Shut up and sit down, because you guys aren't talking out loud and you're all almost definitely sitting or laying. Nobody's standing, and I don't have to sit here and wait for you guys to finish your conversation before I can do my job. But I'm going to an amusement park on Thursday with my coworkers. Yes, sir. Oh man, it's gonna be fun. I can't wait. I cannot wait. I did not get to go. I was going somewhere on Thursday. No. Sunday. Oh, I was going to see that movie with my daughter, and he wasn't playing, so I didn't get to see that movie, that Billie Eilish movie. But maybe this week, who knows? Yeah, I need to be able to do that. I tell coworkers too, but I would rather tell the people at the tables too, because if they would just shut up and listen for 1 second, they would have the answers they need. Hi, I'm Kathy. What? Coke, please. Coke, please. You know, it's $3, right? Mary's here. Hi, Mary. Oh, man. All right. We are going to watch... Oh, look. Nothing. It's black. Let's just do that today. Let's just watch nothing. Here we go. Fraud. Fraud, guys. Lots of fraud.
Forward, you Judge.
Okay, we are here in cause number 4060-22408-CC 2195. Mr. Peacher, can you hear me okay?
Yes, Your Honor.
Good morning, sir.
Good morning, Your Honor.
And who do we have for the state?
Joshua Farrow, Your Honor.
All right.
I lost my tip, Granny.
And Mr. Peacher, we're here on your motion today. So why don't you go ahead and tell me, I think Mr. Farrell is new to this case, so
I've decided 1,000%, Bren, yes, when I move into my new home, cooking videos, absolutely, definitely.
let's go ahead and
Not on this
argue
channel.
your motion so that he can be up to speed.
I know it's been longer than 21 months. You are another OG, been around from the beginning, and I really appreciate it. Thank you so much.
Thank you, Your Honor. But Mr. Farrow's not new to the case, but I think he just hasn't been present for past couple of years. His co-counsel has been. But Your Honor, I'm here to ask for the appointment of representation. According to the Indiana Supreme Court in Nixis versus Cotton, 2004, case the citing is 810 Northeastern 2nd 1003. The court has wide discretion in selecting how this trial will proceed, including by teleconference if it wanted to, meaning like we are now Zoom, or securing someone else to represent me at trial. After evaluating my needs versus or need and to present against the concerns of expense, security, logistics, and docket control. This case is connected to a case that's pending for trial right now in LaPorte Superior Court. It's Peacher versus Lieutenant Jones, cause number 46 D as in David 04-2310-PL-001990. In that particular,
You guys have got to wait until Josh starts speaking. Once Josh starts speaking, everything gets better.
Particular case, Your Honor, I had made accusations against several defendants. At some point in time, I filed a motion due to spoliation of evidence due to the fact that defendants had altered videos on a couple of different dates, destroyed evidence, and did not document things correctly. The defendants responded. The courts granted my partial judgment due to spoliation. They issued a monetary sanction against the defendants, as well as they're going to permit me to issue an adverse jury instruction if this matter is not settled. This case is directly related to that because part of the evidence in that case, I'm alleging that defendant Davis in this case withheld and destroyed that evidence to try to prevent me from prevailing in that case. Because of that, Your Honor, I have to make or set the foundation and make connection between the defendants in that case and Mr. Davis in this case. I have it on a personal knowledge that friends that are both of this defendant and the defendants in the Jones case have mentioned discussing the Lieutenant Jones case. And based off the information that was provided me is why I brought this case before the court about Mr. Davis deliberately trying to involve himself in that other case by withholding and destroying evidence related to that case. The defendants in this case, or the defendant in this case, has managed to get this case dismissed once before, which required me to go to the Court of Appeals and have this case reversed and remanded, trying to avoid addressing this matter. It's becoming very difficult for me to, or at least it appears, Your Honor, just in my opinion, that there's a little bit of bias sometimes in the court when it comes to custody staff versus me because of their previous successes of attempting to make it appear that I have committed some type of violations or fraud before the court by providing fraudulent documents. I've always contended I never did that, and I've attempted to now cover myself by making sure I can prove that it's always the state that is doing that. I managed to do that in that Peacher versus Jones case by catching them altering video and proving to the court that it's not me. There are discovery matters in this case that I expected there would be a problem. Some of my discovery matters that I've been waiting on since December have never been provided to me, but the defendants have also objected to giving me discovery when it comes to Mr. Davis's phone records and social media, which is what I have on good authority. There have been discussions between the defendants in that case and Mr. Davis on interfering with that case, which is the reason why this case is forward. I don't know if it was Mr. Farrell or Miss Cross. Make sure it was Mr. Farrell. He objected to my request for documents dealing with Mr. Davis's mobile phone service and text messages and other information, and he cited the Indiana Code 514.3-4, subsections B, subsection 23, which would threaten the safety and security and orderly operations of the DOC. I anticipated that, which
They were really popular when I was a little girl. We used to put as many as we could into our mouths at one time, as many of the red hots, and then you would suck on them to get all the hot stuff off, and then you would complain and, oh, it really isn't that hot. It's not like jalapeno or anything. And then they're really good. Then you can chew them up and they're good.
is why I'm asking the court to appoint me representation, because it is absolutely relevant and critical that if the defendants in the Jones case were talking to Mr. Davis in this case and to help them overcome their culpability in that case, I need to be able to see that information. And if it's in his phone records, social media records, or emails, I need to be able to see that. If the defendants don't want to give me direct access by citing that threat, I think it's prudent not only on behalf of his personal safety, if he's thinking that, but to allow the fairness of this for me to proceed, for counsel to be appointed to me.
Oh my God, yes. Happy birthday, Kelly. Happy birthday. It's your birthday. And when I created this stream, I was going to write as the title, Happy Birthday, Kelly. And then I just... So, if you're wondering what he's talking about, let me tell you what he's talking about. He wants the all private text conversations of a couple of the prison guards off of their phones, all of them. And the prosecutor is saying, well, maybe he's not allowed to have that. No, we can't have inmates getting access to the CO's personal information.
To deal with these discovery issues in order for me to determine what it is or isn't there and what I'm looking for. I think all of the things that I have requested from the defendant that has not been provided to me, and other discovery as well as the discovery I just mentioned, are all relevant. And I think the courts are going to have to make a decision on whether to compel the defendants to turn those things over. I just think if the courts were to appoint counsel, this would be in the best benefit of the public, best benefit of the defendant, best benefit for myself. It would ease some docket control by preventing me having to repeatedly come back before the court to deal with discovery matters and to argue these things when these matters are critical to proving that Mr. Davis was attempting to interfere in the Peacher versus Jones case by withholding and destroying evidence that pertained to that case.
Mr. Peacher, what efforts have you taken to obtain counsel?
I submitted to the court. I've written several counsel.
Get her?
1, 2,
What do you
3,
mean
4,
get
5,
her?
6,
Who am I
7, 8. I had requested 10 counsel prior to filing that motion. I've continued to write other organizations. My most recent was the
This is a pretty huge birthday, isn't it, Kelly? 65.
Northwestern Project. I believe that's at the University of Northwestern, attempting to try to have someone intercede, at least if nothing more, during the discovery process for me to try to resolve these discovery matters. And then if that's all the court permitted, then thereafter, if I had to go it alone, I would attempt to do so from that point.
What is the status of your commissary account?
There's nothing.
Okay. All right, let me hear from the state.
Here we go, guys. Here we go.
Mr. Farrell?
Yes, sorry, Your Honor. Just at this point, we'd like to make the court aware of some decisions that were made in other courts, both state courts and federal courts, that we'd like the court to take judicial notice of. First is a case out of LaPorte Superior Court 2, 46D02 2312 CT 2292, Robert Peacher versus Patricia Everly, in which the court found, or in which Judge Stallbrink found that Mr. Peacher had forged documents.
I'm like 100% sure that's Judge Stallbrink right there. Wait. I'm really sure that's Judge Stallbrink right there. Right? Oh, am I stupid?
In relation to that matter, and presented them to the court as being accurate. The court found that Mr. Peacher had committed this forgery in an attempt to defraud the court and the state of Indiana, and as a sanction, it dismissed his matter. I'd also like the court to draw the court's attention to an appeal from the United States District Court for the Southern District of Indianapolis, number 1 18-CV-03044-JRS-MJD, in which the court of the United States Court of Appeals for the Seventh Circuit affirmed other sanctions against Mr. Peacher for falsifying documents in relation to cases. So I just want to preface my arguments
Judge Thorne.
with this.
Okay, they look similar. The judge that we saw yesterday, that was definitely 1,000% Judge Stahlbrink, and that's Judge Thorne. Judge Clymer looks very, very similar too.
Understanding that Mr. Peacher is a known forger and perjurer that routinely commits these criminal acts to harass his jailers and to attempt.
Don't be silly, Bren. You can't fly.
To defraud courts out of maliciously, and so with that in mind, I think the court should be very wary of essentially roping in an attorney into this fishing expedition.
So in case you missed it, he had already been charged with forging documents for his court cases. He submitted false documents to the courts to win his court cases and was caught a couple times.
With such an unreliable client, and I think that the effect that would have just on the attorney alone would be substantial enough to deter the court from forcing that on someone, or so for that reason, I think denying this motion is wise. But furthermore, this is a property loss case, Your Honor. Mr. Peacher has a habit of, when things don't go well for him in one case, he files another case, which rather than contesting the facts of the original case, he files another lawsuit alleging that someone else interfered with the lawsuit. And this is just something that he does over and over again. And given that he's wasted enough time of courts in LaPorte County already, I think appointing counsel, who will most likely have to withdraw due to ethical concerns with representation of Mr. Peacher, that's just it's just not worthwhile. But moreover, this is a case in which Mr. Peacher is making purely conclusory allegations. He's essentially manufactured a conspiracy theory, and on the basis of a small amount of lost property, he's essentially just manufactured this conspiracy theory. There's no reasonable factual basis for any of the allegations in his in his complaint against Officer Davis, particularly of any allegations that he was somehow malicious or intentionally deprived Mr. Peacher of property. The allegation here is that some property didn't make it from one facility to another. That happens. The state of Indiana has a statutory process for addressing these claims, and it's a tort claim process against the Department of Correction. And so allowing Mr. Peacher to turn this case into a fishing expedition, and that's exactly what it is. Mr. Peacher wants to invade the privacy of a correctional employee. He wants to review all of his private communications, even though we've already responded to his discovery request, pointing out that there are no relevant communications. Officer Davis has never discussed this case with anyone, particularly outside of my office and the normal process of responding to tort claims. He has no personal communications about this case. And so essentially what Mr. Peacher's attempting to do is have the court pay an attorney to invade the privacy of a state employee for no reason, based on conclusory allegations that there's no evidentiary basis for, and the fact that there is no and the court had previously found that there was no evidentiary basis for these allegations. Unfortunately, the Court of Appeals decided that that he, for some reason, Mr. Peacher didn't need evidentiary basis to maintain this claim, but that doesn't entitle him to representation. And furthermore, if there was any basis, in fact, to what Mr. Peacher was saying, or in these allegations that he was making, then it seems to me that an attorney would be more than happy to assist him on this case. If his conspiracy theory had any basis in reality, then he would be able to find counsel on his own. And for those reasons, we just ask the court to deny this motion.
Yeah, reply, Your Honor.
You may.
Your Honor, when it regards to, once again, the defendants are attempting to try to capitalize on
Shit, I was muted. Josh, I was muted. Okay. All right. This is the problem. Looking at the judges, it's very difficult to see who is who. Okay. So in the top, we have Judge Stallbrink, who looks very, very much like Judge Clymer. He is bottom right. And then Judge Thorne is left. And the problem is, Judge Stallbrink doesn't often have his camera on him. He does when he's in this courtroom, but then nope, I'm wrong. He's always in this courtroom. A lot of the times he only has the camera pointing to the gallery. So just by looking at these three judges, it's almost impossible to tell who is who. But since you guys are vibers, you guys are going to have to pick up the slack and tell the difference. Stallbrink is on the top, Thorne bottom left, and Clymer bottom right. That way when you see a clip come on from me, you know who they are, because other channels are starting to play my Indianas. Not a lot, but they are. And we're going to need to know our stuff if we're going to wander into another channel and see a judge. Say, oh my gosh, Judge Clymer, Kathy's been showing him for 2 years now. Yeah, I know. I just wanted to show you why you weren't really in error. They look identical. They could all be the same dude.
the most recent Peacher versus Everly that Mr. Farrell points to, where Judge Stallbrink dismissed the case, stating that there were fraudulent information. Unfortunately, the judge did not review the information because Mr. Farrell attempted to do this in the also pending Peacher versus Beatty case, and Judge Link caught the fact that the documents that they were alleging were fake are not fake, because they used it in the Peacher versus Lieutenant Jones case to try to defend themselves. So the argument was that I created a fake stamp that the facility had never used. But in Peacher versus Lieutenant Jones...
Yeah, I did. I pressed play and I muted the thing and not me. Bren, I bet you know the name of some of the judges. I bet you do.
The defendants used that very stamp to try to defend themselves.
I'm going to
So
prove it.
it was conveniently that it
prove
exists
you
in the Peacher
No.
versus Lieutenant Jones case, but in the Peacher versus Everly and the Peacher versus Beatty case that's still pending, that somehow that stamp no longer exists and had never been used before. Your Honorable Judge Link caught that, and he denied the defendants that bogus argument.
Judge Link is Magistrate Link. He's the really, really good one when he gets mad, but he never gets mad. But he's so good when he gets mad.
In the Peacher versus Beatty case, because the stamp does exist. It's unfortunate that Judge Stallbrink did not see that information, even though it's on the court docket in the Peacher versus Lieutenant Jones case. So I have presented that stuff to the Court of Appeals and expect that matter to be reversed and remanded once again, hopefully with the courts now once again for this, which will now be the third time in recent months, reverse and remanded a decision back because the defendants are not being genuine. In this case, Mr. Farrell has just made the same argument that he managed to get Judge Thorne to dismiss this case, and the Court of Appeals once again reversed and remanded this matter, which is now before you, because this case and the stuff that I'm requesting is directly relevant to the Peacher versus Lieutenant Jones case. Mr. Farrell is trying to slightly move the arrow, shift things by saying that my request for discovery is a fishing expedition for matters in this case. But my request for discovery is to demonstrate and to pull the evidence of the fact that Mr. Davis and the defendants in the Lieutenant Jones case discussed that case, and Mr. Davis then helped them or attempted to help them by removing evidence from that case and destroying it. That's the reason why the Court of Appeals reversed that. So this is not a fishing expedition. I was informed, which is the reason why at the time I wasn't even sure that I would succeed in that case without that evidence, in the Lieutenant Jones case without evidence.
He's damn lucky this is not a fishing expedition. Could you imagine if he had Judge Fish on this?
Was informed that Mr. Davis had did this, and is why I brought this matter before this court. It's not a fishing expedition. I was told by not only a friend and a colleague of most Mr. Davis and Lieutenant Jones, but they actually, it could be considered coercion or a threat for me to let the matter go and go easy on the defendants and not actually pursue this.
Mr. Peacher, what is the cause number that's in front of Judge Link that you're referring to?
The Peacher versus Lieutenant Jones case is 46 DO4-2310 -P as in Paul, L as in Larry, 1990.
And you say that's the one that Judge Link found for you?
That particular case, Your Honor, I filed a motion for judgment due to spoliation evidence. In the defense of the motion for spoliation evidence, the defendants in that case provided documentation with this stamp on it. That stamp, when they were trying to defend that position, is now the stamp they say does not exist when it came to the Peacher versus Everly case, where they managed to trick Judge Stallbrink into believing that that stamp doesn't exist. But it's literally on the court docket submitted by the defendants.
Have you ever requested counsel in any of these cases before and been granted counsel?
I have not been granted counsel in the other cases, but I did request it. I was not granted. Judge Link, there were no discovery issues when it came to these personal issues like this with the privacy of Mr. Davis's information, personal records at stake, which is the reason why I anticipated this would be a sticking point that I would need to show that Mr. Davis colluded with the other defendants, as had been told by me by one of his colleagues, which I have asked for the defendants for the particular staff member's full name, and have not been provided that information in order to try to subpoena him. And therefore, I knew that there would become a point where counsel was going to have to possibly be involved to respect and protect the privacy of Mr. Davis while allowing me to confirm what has been told to me by Mr. Davis's colleague and the defendants in the lieutenant, or in the Lieutenant Jones case.
Let me go to Mr. Farrell. Mr. Farrell, are you objecting to the release of the discovery based on what?
Well, first of all, Your Honor, it's not relevant. Mr. Peacher has requested all personal communications of any kind, essentially, that Officer Davis has ever made. That's an outrageous request. It would be an outrageous request if it were made by an attorney.
It is an outrageous request. It's unbelievable that the judge is even thinking about it.
So
That's not true, Your Honor.
Jeez, do you have any idea how, oh my gosh, how unsafe our prison officials would be? Our prison guards would be if the inmates could get all of their personal information?
I'll let you get back to that in a minute, Mr. Peacher.
To the point which that's the case, it doesn't really matter whether there's an attorney or not. We'd be objecting to that either way. But moreover, the personally identifying information, personal communications, all of that of correctional officers is by law barred from disclosure. So we're not able to produce it. It would be against the law. But moreover, there is a security issue. There is the order within the prison. If prisoners could just had free reign to flip through all the personal communications, all of the text messages, emails, social media postings of every correctional officer, then that would be extremely harmful to the operations of the facility itself. But more, and so that's our objection to those to those requests. But more importantly, we have responded to them. There are no responsive documents. There's no relevant communications. Officer Davis did not,
but I don't remember before that.
Communicate about this case with anyone outside of normal channels, and those, of course, are related to the notice of tort claim. And of course, any communications that happens about this case after the receipt of a notice of tort claim would be protected by the work product doctrine and the attorney-client privilege. So other than that, there's just nothing to be produced that's relevant. And if I could just address some of the other things that have been said in this case, said by Mr. Peacher just now. Once again, he's drastic.
I buy a roll or two every week of stamps, but I haven't a clue how much one single stamp is because I buy 100 or 200 at a time, and I use a company card. So my daughter works for a company that needs a lot of stamps. So we run into the post office with a company card, and we don't care how much it costs. No idea how much one stamp costs. 55 cents sounds right to me.
Drastically mischaracterized things that have happened in other cases, and that's strategic. He doesn't want to make these arguments in front of judges that have already reviewed the evidence that he's talking about, and so he loses in other courts, and then he files lawsuits in a different court so that he can lie about what happened in previous courts. I
just won.
Furthermore, Mr. Peacher is stopped from challenging, really contesting his forgery by issue preclusion. If he wanted to prove that his forgeries weren't forgeries, then he needed to do that in those courts in front of the judges that made those decisions. It's not appropriate for him to essentially just manufacture this case as an attempt to get somebody else to look at his cases and essentially have one trial level judge review the decisions that were previously made by another trial level judge, and that's just not appropriate under the common law.
Mr. Peacher.
Your Honor, first, I was never asking to see all of Mr. Davis's case. I specifically was specific about the dates, between which particular dates, and his communication between him and the defendants in the Peacher versus Lester Jones case. That's the only thing I requested. I anticipated that they would make the objection, but I was specific and it's relevant. Mr. Farrell wants to continue to talk about there's no documentation for this case, but this case is directly related to the Peacher versus Lester Jones case, which is what the Court of Appeals is why they reversed and remanded this, because of the fact that I have made the argument and allegation that Mr. Davis attempted to help his colleagues in the Peacher versus Lester Jones case by taking evidence. And Mr. Farrell wants to characterize it as simply saying some documents are missing. The only documents specifically that were missing were the documents relating to his friends. And I've only asked for access to...
I would buy stamps all the time then if there was chocolate flavored stamps.
To the text, social media message, emails between him and those individuals in that case, only that case, because the allegation is for this that he tried to collude and help his friends in that case win. Now, Mr. Farrell wants to talk about the fact that that I am trying to argue my alleged claim of forgery, and I'm assuming in this case, but that's not the case. He brought up the Peacher versus Everly case that Judge Stahlbring dismissed. I was simply stating that case is pending appeal, and it's unfortunate that they were able to deceive that judge, which will clearly be presented, that the evidence that they're saying that this particular stamp doesn't exist was submitted to the court by them as existing. It just happened to be in another courtroom. And then in this particular courtroom, they told the judge it doesn't exist. And I was only pointing out for the court at the time that if they looked and took judicial notice that in one courtroom they said that stamp exists, and then in another courtroom they saying the stamp doesn't exist. That's, not to use a legal term because I don't have one, that's dirty pool, Your Honor. If the stamp exists, it exists. If it doesn't exist, it doesn't exist. It can't exist in one case and then say in another case they've never used it before. I managed, unfortunately, the judge did not look at the fact that the staff, administrative staff at this facility provided me documents which I submitted to the court stating that stamp exists and it exists at Westville. So they managed to trick Judge Stahlbrink into believing that. And I believe that when the Court of Appeals reviews everything, they will be exactly what I'm stating. If the stamp exists in this case, in the Peacher versus Jones case, and they used it to try to defend themselves saying, here's some documents with the stamp on it, this is real, you can't turn around in two other cases and try to say that the stamp doesn't exist. And so Mr. Farrell is trying to capitalize on the fact that this particular point, that case has been dismissed, but I am under the firm belief, just like the most recent two cases will be reversed and remanded by the Court of Appeals, because now I have been able to learn how to defend myself against the defendants falsely claiming I am the person forging documents when it is in fact them submitting false information and evidence and testimony to the court, making it appear that way. They've just been caught once in the Peacher versus Lieutenant Jones case. They were caught again, but the judge just simply denied their claim that the stamp didn't exist in the Peacher versus Beatty case in LaPorte County. And I am firmly believing that the Court of Appeals will do for the third, fourth time coming to reverse the Peacher versus Everly case and send it back down to the LaPorte court. But hoping this time they will just sanction the defendants for once again trying to deceive the court by making it appear that I did something when it has in fact been them. And that is the reason, Your Honor, at this point, I am trying to seek counsel because of this gameplay that they can do. I'm not, if the attorney that potentially can be appointed for ethical reason believes that he's putting himself in jeopardy by representing me, I will accept that. But I believe when that counsel sees and he goes and looks at the Peacher versus Lieutenant Jones case and sees that that information was submitted by the defendants as valid and existing, and then turned around in two other cases and said that information doesn't exist, he will understand that it's not me that's forging documents. It's not me presenting false information. It's the defendants. They've been caught twice now. They will have been caught a third time when the Court of Appeals reviews the information and sees that they used it in one case as valid and then attempted to tell the judge in another case that it doesn't exist, especially when DOC officials are saying that it does exist. So, Your Honor, I was just simply trying to solve this problem of being able to see communications that I was told existed between May 25th and present day of Mr. Davis communicating with his friends about that particular Lieutenant Jones case. Mr. Farrell wants to continue to say there's no relevant documents for this case, but I am referring to the fact that Mr. Davis communicated with the defendants in the other case in order to help them by withholding and removing critical evidence for me to litigate the Peacher versus Lester Jones case.
Yeah, but just saying it's critical evidence does not overcome relevancy. You have to say why it's relevant. And just saying you think they were talking about your case. I mean, I think that he has to absolutely bring something to the table to get personal information from guards.
To protect him, to protect Mr. Davis's privacy, but to still allow me proper discovery, I thought it would be prudent to have counsel appointed who I could discuss the matters with. He could then receive the...
Yes, sir, but every single lawyer you spoke to said nope, absolutely not.
Discovery. He could review the matters, pull out...
Oh, that's another thing they're fighting here. He wants a lawyer. He wants the judge to appoint a lawyer for this case. And the prosecutor's like, don't do it. He has already been tried and found guilty for fraud a couple times. You are putting a lawyer in danger if you appoint him a lawyer.
What things are necessary regarding the case to show that Mr. Davis colluded with the other defendants in that other case and still protect and maintain his privacy.
Any response, Mr. Farrell?
Yes, Your Honor. Just to address the Peacher versus Jones case, Mr. Peacher filed a motion for summary judgment. We moved to strike his evidence, including on the basis that he had some of the evidence that was designated was forged. The court denied his motion for summary judgment on the basis that he had failed to authenticate that evidence. So once again, he's mischaracterizing something that happened in another court and asking this judge to supplant, to this court to supplant
Mr. Farrell's confused, Your Honor. I haven't filed a motion for summary judgment in the Peacher versus Jones case. I filed a motion for judgment due to spoliation of evidence, and the courts granted it partial judgment of the spoliation evidence and issued a monetary sanction against the defendant.
Your Honor, again, he's just mischaracterizing. he's mischaracterizing what happened. He'd previously used a forged document in the Everly case. He did it again.
Hold on, see, he switched from the Everly case to the Jones case, Your Honor. Now he switched back to the Everly case. In the Peacher versus Lester Jones case.
Listen, I need one of you to speak at a time.
Your Honor, Mr. Farrell.
I'll let you correct him in a minute, Mr. Peacher.
Yes, Your Honor.
And so once again, Mr. Peacher is trying to use this case to relitigate things that have already happened in other cases that are not relevant to this case, and it's not appropriate. We're not prepared every time we come to a hearing on a case with Mr. Peacher for him to go on a tangent about things that he's not happy with in prior cases. If he wants to address the issues with those prior cases, he needs to do that in those cases. And it's not appropriate for him to essentially graft onto this case a discovery dispute in another case, and that has nothing to do with this case. And so for those reasons, we'd ask the court to deny this motion. But more importantly, Mr. Peacher is now just admitting that his discovery requests in this case are just a pretext to conduct further discovery in another case. And if that discovery in that other case is so important, and if there are these discovery issues that he needs to address in that other case, then he can do that in that other case. And it's not appropriate for him to ask this court to inject itself into his other cases just because those cases aren't going well for him. And so he is seriously misrepresented what's gone on in other cases. His claims about a stamp existing that was claimed to have not existed are false. Prior counsel pointed out that Mr. Peacher used a stamp that was similar but noticeably different than what was actually used in the facility. And the court agreed with him, and it sanctioned him for that forgery. And so at this point, that's res judicata. He's precluded from challenging that issue in another court. He had ample opportunity to do so in a prior court. So sort of regardless of whether or not he agrees with the fact that he forged those documents, it's a fact. It's proven through issue preclusion, and he's no longer able to challenge it. And so, for those reasons, we just like the court to dismiss or deny the motion for appointment of counsel. And then just to address this spoliation issue, that's an issue where, due to the software of the camera equipment, a single second was not captured on the video, and now Mr. Peacher is trying to misrepresent that an issue in that case and try to make it relevant in this case. And again, I just like the court to keep in mind that this is something he does in all of these cases. It's just how he fills his time. It's a hobby of. I can read the orders in the.
The prosecutor is getting a bit unprofessional here. Stick to this case. Stick to these facts, sir.
Jones case, and I can interpret them for myself.
Thank you, Yuri. So for those reasons, we just ask the court to deny his motion.
Mr. Peacher, go ahead.
Runner, everything that Mr. Farrell just.
Now you have to decide if what Mr. Farrow just said is a lie and what he is about to say is true, or the opposite, because they both can't be true.
Said to you was a lie. First, with the Peacher versus Jones case, I didn't file a motion for summary judgment. I filed a motion for judgment due to spoliation evidence because the defendants destroyed evidence and they altered video footage. Mr. Farrell just tried to characterize it saying there was only 1 second that was missing. There was literally 1 minute and 11 seconds missing in the middle of the video that couldn't be characterized as a glitch. In fact, the 1 minute and 11 seconds in the video was the very time of the incident that is the catalyst for that case.
I'm going with that's a lie, but I don't know. But that's where I'm leaning.
So no other time did the video glitch. It just happened to glitch on the exact 1 minute, 11 seconds in the middle of the video. That is the foundation for that particular case. Judge Link asked for an explanation for what happened. The defendant's first response was, I ambushed them with their own video. Then they went and found out, they later on asked the courts for an opportunity to come up with an explanation of why that video footage was missing. And they tried to claim that their recorded video, that they later Everly case and claimed that it's not real. They said it doesn't exist. It never existed before. The documents that they said that had the stamp on it didn't exist is actually in the DOC's record system, and it has the stamp on it. And I provided that to the court, and unfortunately, Judge Stallbring did not see those things for whatever reason. But I am certain, just like the past 2 attempts that they've had cases dismissed making these false claims, the Court of Appeals has reversed and remanded these matters. I'm not trying to litigate that particular part. Mr. Farrell brought up the Peacher versus Everly case and tried to make a claim about forgeries and stuff like that, but they've already been caught altering video. I simply was asking the court to appoint counsel for these discovery matters to protect Mr. Davis. Mr. Farrell tried to characterize it saying, I wanted all his messages. No, I was specifically asking between specific dates and his communication between the defendants in that other case. I am attempting to do discovery for that case, and I am being met stonewalled as well as that case. But I didn't bring that matter up. I brought up the fact that in this case, Mr. Davis, upon learning that he was communicating with the defendants in that case and assisted them in withholding and withdrawing evidence.
Whoa, that's not what you said. You said that his friends were communicating with the defendant's friends. That's what you said.
Withholding and destroying evidence. I wanted the communication between him and those particular individuals for this case. I've made the allegation that he colluded with them to cause this harm. They tried to say there was no, they tried to have this case dismissed, and the Court of Appeals saw it for what it is. Mr. Davis has done something outside the scope of his employment by trying to collude with these individuals to interfere in another case. I have everything that Mr. Farrell has just attempted to convolute is just simply not true. I'm not trying to relitigate something about a forgery because I have not, other than the Peacher versus Everly, the Peacher versus Jones, and the Peacher versus Beatty case. Judge Link saw that those things that they were stating about a forged stamp and documents were not true, which is why Judge Link sanctioned them with a monetary sanction and is allowing the issuance of an adverse jury instruction. He didn't do that because I did something wrong. He's sanctioning them. So they continue to try to make this allegation because they managed to get away with it in the past that I had forged some documents. I am learning, Your Honor. I am not an attorney. I didn't expect staff to all collude. I can understand why a court, if they have 4 or 5 staff saying one thing versus one prisoner, why the courts would believe the staff versus the one prisoner. But I have learned from those mistakes of being exposed to the attempt of trying to make an allegation and then colluding together to say something different, which is why I've been able to continue now to catch them, which is why 2 of these cases have been reversed and remanded, which is why I'm confident that when the Court of Appeals looks and sees that the stamp that they've tried to say is not real, that Judge Stallbring did not review completely, when they see that it was used in the Lester Jones case, when they see that the staff of the Department of Correction say at a different facility say that stamp exists, they will reverse and remand that case as well. So for Mr. Farrell to make those claims and continue to try to hang his hat on, that's the reason why a counsel should not be appointed, it's just all smoke and mirrors, Your Honor. It still doesn't negate the fact that Mr. Davis, my allegation, based off the information provided to me, attempted to do something that was illegal. He withheld evidence that belonged to another case in an attempt to help his friends and colleagues defeat me in another case. I am simply asking for discovery that relates to his actions of what he did to help those individuals in that other case. It's not just merely stating I've lost some documents. This had an effect, has a potential adverse effect on another case.
Yep.
Hopefully, by the fact that the judge has now sanctioned them monetarily and is issuing an adverse jury instruction in the Peaches versus Lester Jones case, I may have the ability to overcome what Mr. Davis has attempted to do in helping his friend.
So if you're scared of a butterfly, you have good reason to be scared of a butterfly. Did you see that?
But that's not guaranteed. Don't know what a jury is going to do when that time comes, unless this matter is settled. But I'm basing it on the fact that I'm going to go to a jury trial in just a few months. So I have to pursue this because of what they did to me. And the only way to completely confirm what has been told to me is to review the communication between Mr. Davis and those particular defendants. That's all I've been trying to obtain. They don't want to provide me those for Mr. Davis. I anticipated that, which is why I was trying to seek counsel to just help me deal with that part of the discovery. If there's nothing there, there's nothing there. But if there is something there, which is what has been told to me by one of their colleagues, which they don't even want to provide me his...
No, sir. No. You cannot just say, oh, well, if there's nothing there, my bad. Oops. No. You have to prove there's something there first before you get that stuff.
Full name so I can subpoena him. Then, that's just another attempt.
If it was Bren's information, yeah, you can have it. But this is a prison guard. You cannot have their information. No. So, yeah, butterflies are scary. You just saw a picture. They're very terrifying. But, you know, you really could just walk away. Just like funnel web spiders. You can just walk away. Just because we're scared of something doesn't mean that it has to die.
Of what the Court of Appeals just tried to explain or tried to state, that there is a factual finding or foundation for me to make this allegation that Mr. Davis attempted to help his co-workers defeat me in another case where they were losing, where Judge Link has now caught them altering video, has issued a monetary sanction against them, and has now stated that an adverse jury instruction will be issued if this matter goes to trial. I think, Your Honor, the fact that since December, they have not, I believe it's December.
I will happily share Bren's information
to not provide me with discovery in many places, or excuse me, since March of this year, Your Honor. They've not provided me certain discoveries. I've asked for documents that are clearly relevant, inventory, property forms, things like that, that they still just do not want to provide me. I thought it would be in the best interest of the public, the defendant himself, and me to have counsel in the middle, allow him to obtain this discovery. The things that I am stating I'm looking for, he can search through once it's been provided. If the things are there, they can do the necessary redactions of phone numbers or email addresses or whatever, and I will have that evidence to present to show that Mr. Davis and those other defendants had a discussion about removing stuff when I transferred from that facility in order to defeat them in that case. Mr. Davis has put himself in that case. This case reflects that, and he should be held accountable for that. And the only way I can do that is to be able to obtain discovery to be able to show that from point A to point B to point C, Mr. Davis did his improper involvement in trying to help defeat another case.
All right, Mr. Peacher. I understand the issues. The court's going to take a look at this. I'll take this under advisement and I'll go back. I will look at the cases you guys have cited to me, and then I'll make a decision on your request for assignment of counsel.
I don't think I gave you the Peacher versus Beatty case, Your Honor, where they attempted to also claim that the
Monica,
same
thanks for
stamp
the
was not
cheers.
real and existed, and the courts denied their motion to try to dismiss the case in that. But I can try to find that cause number and provide it to the court. I have it in front of me if you'd like to have that one as well. It's Peacher versus Beatty, Your Honor.
I'm sure I can find it, sir. I'll take a look. All right. Have a good day.
Thank you, Your Honor. Have a good day.
We'll keep an eye on this
Have a
guy.
good weekend.
We'll see if next time he shows up he has counsel. I'm guessing he does not have counsel. I'm guessing the judge is going to make him get his own counsel. But who knows?
It's a little bit early, but can we start?
I think so. You want to, okay, Judge Mr. Fuller,
Oh, okay.
we had previously given notice of intent to argue bond.
Okay. Sure,
They're pretty
spicy.
vicious, aren't they, Fox?
Judge, Mr. Fuller is being held on one of these cases, 25M 2185 on a PR bond, and on 25M 2464 on a $1,000 cash only bond. It appears that he is set for a felony trial early June, and in that case, from what I can tell, like he's got a PR bond in that case. I think the alleged victim is the same person in both cases. We would ask that we modify the bond in 25M 2464 to a PR bond. I know that the prosecutor was going to be doing VRA compliance, and I don't know what the result of that was.
Mr. Craig.
Judge, I apologize. I didn't.
Is it two E's, Mr. Fuller? Two E's?
Yes, Your Honor.
Okay.
Judge, I think the bonds are set appropriately. In this case, we did deal with this back in October, and then we kind of went into competency issues. The problem is just we have the felony case, it's the DV. We have the 25M 2464, which is a DV. And then we have the other one that's pending, just the number of cases.
You got to get two otters, not one. Because they float and they hold hands when they fall asleep so they don't float apart. You can't have just one otter.
Is present with the protection order in place in at least two of these now. I think it's clear that Mr. Fuller struggles with complying with
I just didn't remember she was scared of moths.
court orders. We also have the VPO in 2022 that was a conviction, and then two more VPO DVs, one in 2013 and 2019, that are also present, but they're not convictions.
Your Honor, may I say something?
Just a second, Mr. Fuller. I'm looking up your.
Yes,
other
please
case.
say something, please.
Okay. I was just looking, I was reading the motion that was filed in 20 CR 1125.
Yes, Your Honor.
I hadn't seen that one before. It was just filed last week.
Your Honor,
Yes.
I have been a model prisoner here in your jail.
He's been a model prisoner at the jail.
I have not gotten in trouble. I have not gotten stripes.
He's completely changed. He's on the straight and narrow now. He's a good guy, Judge.
For a year. I've learned my lesson. I'm humble. I'm a born again Christian on top of it.
He's humble. He's humble, Judge.
I've taken JPBS twice. I'm about to graduate tomorrow or whatever it comes next. I have not been sitting there idle. I've learned my lesson.
He learned his lesson, Judge.
And I don't ever want to see her name is Kimberly Kelly.
Okay.
I don't ever want to see her again, ever. She's a dirty ass rat.
She's a dirty ass rat. Judge, I'm humble. I've changed. The victim's a dirty ass rat.
You know,
Mr. Fuller, I don't need the language, okay?
my apologies, sir.
Yeah. Yeah,
My apologies.
all right. Court will modify the bonds to $1,000 PR bonds with pretrial services supervision. Part of that is the length of time that Mr. Fuller has been in custody without the bond being modified. The same no contact orders remain in effect.
Yes, sir. Yes.
Do you understand that?
Oh, yes, sir. Oh, yes, sir.
Okay.
I will not ever contact her again, ever.
Okay. We'll bring it back on June 2nd,
He's currently trying to call her right now as we're playing this, I bet.
Tuesday at 10 a.m. and then we'll see what the status of the case upstairs. I think that's scheduled for the 8th.
He's humble. He's changed. Oh my gosh.
The court is going to call its case number 2026 CR5. That case is entitled People of the State of
He's
Colorado
calling her right
versus
now.
Christina Taylor. The record in this case should reflect the appearance of the people through District Attorney James Bull.
Okay, hold on, Maiko. Only one of your hands work. So are you really washing your hands every time right now? Are you just saying, ah, screw it. My hands don't work. I'm going back to bed.
Like Christina Taylor is present
No,
in
I don't have
person.
that.
She appears.
I sort of have it set up, Donald, but not really because I have the whole chat there so you can... So I sort of have it set up. I sort of need to put more effort into it to highlight certain posts, but it's a huge pain in the tush because now I have to decide, oh gosh, I highlighted Monica 3 times. Now I have to highlight Bren 3 times. Oh no. And I get, oh, you always put that person's comments up on the screen, but you never put my comments up on the screen. And I don't want to, I'm not in the mood to listen to that 3-year-old bull. So I'm probably not going to put any effort into it because they're all right there, Twitch and YouTube.
With her attorney of record, Jeremy Lytle. The matter is before the court today for a sentencing hearing. Mr. Bullock, are you prepared?
I am.
And Mr. Lytle, are you prepared?
Some of the audio here is iffy, but do not worry. We were going to hear more than enough. Monica, I'm pretty sure I said thank you for the cheers, but just in case I didn't, thank you for the cheers. Thank you.
Your Honor, I am prepared. My client seems to not be prepared.
Shut up. I use effort.
Don't understand.
The court hasn't proceeded yet with anything. The court would like to hear from the parties related to their argument, and then I'll make a determination related to Ms. Taylor after the court hears from her as to whether it's a...
In case you missed it because I was talking, they're supposed to be here for a plea sentencing that she already pled to. She has pled guilty. She signed the plea agreement. And now it's the sentencing. And we're here ready for sentencing. Prosecutor said he's ready. Defense attorney says he's ready, but he doesn't think his client's ready. And my client just said, I don't understand.
appropriate to go forward today or not. The court is proceeding pursuant to the parameters of a plea agreement that was entered
Blood,
into
sweat,
on
tears. That's
April
what I pour
6th.
into this.
A
And coffee.
summary assessment has been done by probation since that matter. Court notes that the sentence here is a probationary sentence with no upfront jail. Court would ask Mr. Bullock, are you requesting that the court approve the plea agreement?
At this point, I am, Your Honor. I've also notified the court that I'm asking for nothing in addition to the recommendations as set out by the probation officer.
All right. Thank you, Mr. Bullock. Mr. Lytle?
Your Honor, I believe the plea agreement was fair. However, Ms. Taylor and I were talking quite a bit before court. She does not.
If it makes you feel any better, Donald, I called my ex way, way worse than that. Some of the things I called my ex would make your hair curl. So a lazy dog that never leaves the yard really isn't that bad.
Remember entering a guilty plea has advised me that I've not talked to her one time about this matter and that she never pled guilty. Contrary, of course, to many hours of. So this is actually a first for me. I can say that across any jurisdiction,
I remember my first.
I can say that she's not remembering prior.
But I don't understand. I was a victim. I don't understand.
Your Honor,
I don't understand.
I can say, Judge,
Why I can't go home.
without breaking any privilege, I can say that she and I have discussed the case. Ms. Taylor is concerned with matters that may relate but are not necessarily germane to the issues in front of her, in front of this case in this court. I can tell the court that whenever we did enter the plea, she seemed to understand the reason for the plea. However, it seems like today that's not the case, and that's as much information.
All right, thank you.
Yes, sir.
You do have the right to speak. I want to say a couple of things first, just so you understand what we're doing.
Unfortunately, her lawyer just moved her microphone way closer to her right now. So
just see if you can listen. If you can't understand, then we'll see. But I'm not sure that waiting is going to help. But anyway, you are going to go home today.
I don't have to 7th Avenue.
I don't know.
Because that's why I can't go because I was a particular party in the criminal case, and then all this criminal stuff was still going on. Okay, and then I got a bad feeling in the back of my neck, so I went and got in a motel room. When I come back, I got all these groceries and everything. They took my groceries from me, all my property, all my driver's license, my credit cards, all that kind of stuff, my food stamp card. He's the only one that had the PIN numbers on it.
All right,
Okay,
just wait. What you're talking about is the facts of the case, and I don't want.
No, I'm not talking about the case. I'm trying to understand why it did this. I'm trying to understand. I'm trying to understand why I can't go home. I didn't commit any crime. All I did was call the cops, and they still won't take my report. What's going on? They still won't. They lied to me. They thought me to do anything but help me.
All right.
There's all kinds of illegal unscrupulous actions by the sheriff's department to take my apartment back to the house and say, "Oh, we didn't want the dog to die. Even my teeth were gone. All my property's gone." And then they said they gave me his driver's license. Okay, well, give that back to him. I had to walk home. I'm being extremely hurt because the injuries he caused to me. I was held against my will. They took my phones. They dragged up my car. Okay, it was running fine. When I went to go get my dog to get his shots, all of a sudden it went.
All right, I have two sisters, and I've spoken about one of them often. She's a freaking criminal, right? Criminal. This is my other sister. This is what it's like to have a conversation with my older sister. She was so much smarter than me that it was two separate worlds. When me and her had a conversation, she was definitely the smartest person I know. Even at 11, 12, 13, she was unbelievably smart and beautiful. She used to have the feathered hair. Remember? Late 80s, early 70s, when we used to feather our hair in Aquanet? Her hair was perfect. Her brain was perfect. She was the star basketball player on the team, right? This is what it's like having a conversation with her right now. It's unbelievable. You say a word, basketball, and she will go off on tangents about how there's conspiracy theories against her and people are going to die, and it is just like watching this clip is just like talking to my older sister, which I did what? I did it once a couple months ago. You guys remember that? She just showed up at my door. First time I saw her in 2 decades or whatever.
Running. I know exactly what's wrong with that car. I bought the car. I had to work on it, looked up mechanic. He didn't have nothing to do with it.
All right, you need to be quiet for a minute, okay?
I want to go home.
You need to be quiet for a minute. You pled guilty. You've gone through you for whatever. You pled guilty to the offense that you're here for today. You signed a plea agreement. You and I had a discussion about that plea agreement, and you pled to it.
Okay.
So, you know, what that means is the next process is a review process. You went over it with probation, and you're here today for finalization of your case.
Okay, but it's still not final because I still can't go home.
No, and that's not going to change no matter what happens
But I
today.
live there. That's my legal address. He took everything. I don't understand. I don't understand. I didn't do nothing wrong.
It really, you know, in terms of that, the court entered a restraining order. That restraining order is not going away today.
What restraining order?
The restraining order that I entered on February 26, 2026, with you here, you were in court. That restraining order.
For what? Because I didn't break any laws. I didn't do anything.
That restraining order, I'm looking at it right now, and that does not keep you from being at certain properties.
That's the restraining order to protect the party against.
Talk to them right now.
Okay.
Christina.
They quit the restraining order. They're trying to evict me for something I didn't do.
All right.
Okay, they quit it. I got the paperwork right here.
Yeah, you're wanting to continue this not as a result of anything that happened in this case, but
No,
I'm gonna put you in jail if you continue. Okay? You're wanting to continue this case not because of anything that happened in this case, but because you're having a dispute with your landlords.
No.
All right. Are you here? I'll continue the case for 2 weeks if you want, Miss Taylor, but we're going to go forward on that date.
I understand what I don't understand is I was a protected party. We both lived there. The judge said that we had to get along. Okay? And he said, well, I don't know how that's going to happen. But I still got out of jail. We went back to the house. They were still doing illegal stuff. And
Lori loves law. Lori, oh my God. How are you? You're still alive. You're still kicking. I can't believe you're here. I'm so excited. I'm super excited. Lori, how are you? It's been a hot freaking minute, girlfriend. I mean, it's been a long time. We missed you. We really did. Look, you're still blue.
I was still scared. You know, but I lived there. That's my legal address. The reason it's retaliatory because he went to jail. Well, so did I. I wasn't trying to go to jail either. You know, I was just trying to. I'm sorry.
Stop.
But
I understand there's a dispute between you and your landlord. No matter what happens today, that's not going to be resolved. The only thing I'm going to do today is either go forward with this sentencing, which is a sentence to probation without any jail, or I'm going to continue it for 2 weeks.
Well, go ahead. You do that. Go ahead and do that.
Do what?
Forward with the case.
Yes, you are.
Go in jail. But I still understand what is wrong. I still understand because I still want to report what's really going on. And I didn't do anything, and I lived there. That's my animals that are not being taken care of. It's all my property's gone. I don't understand.
All right.
They won't let me report. Neither one of them will let me report what's going on, and I got proof.
Mr. Bullock, what's your position with respect to proceeding today?
Your Honor, I'm troubled, and that is, every indication is that given Ms. Taylor's inability to prevent from interrupting the court, not obeying the law enforcement officer to proceed now for a sentence of probation, I think would be terminated within a week or two. I would have no objection to a brief continuance.
I just got to tell you guys the story. Sorry, Lori, but I got to. Lori was in our stream one night and started to feel a little not okay. And I'm not gonna. It's a longer story than what I'm saying, but you know, we were like, you gotta get it checked out right now. And on her way to the hospital and everything, she collapsed, broke a whole bunch of ribs, and was it a heart attack? But she was on her way, like she was getting herself to the hospital, and so she made it. She was obviously, she's fine and healing, but it was. I think Nan was the one that maybe saved her life that night, saying, "Hey, you need to go right now." And Lori made it. It was scary.
For Ms. Taylor to resolve the complications or protection order issues that prevent her from, in her mind, returning home. But I certainly am not willing to vacate the plea agreement that was previously entered.
Mr. Lytle, are you requesting that the court continue the matter today?
Senator, on behalf of my client, whatever she wants to do, but personally, Judge, I don't have a position because I don't think any of these issues are going to be resolved within 2 weeks ongoing. A lot of them kind of relate to everything, but they're not something I think can be addressed here.
Yeah, that's.
I don't know what that means.
Well, what it means is you've pled guilty to an offense, and now you're arguing something that's associated but not directly related to the offense.
Related to it.
So the court has heard from the people, the court has heard from the defense counsel, the court has allowed Ms. Taylor to speak. So the court is going to now enter judgment and sentence. And it's going to be as follows. The court is going to approve the plea agreement that was entered into this case. So the conviction will be to obstructing governmental operations in violation of 18-8-102 subpart 1B. That is a class 2 misdemeanor. The sentence is going to be probation. It'll be supervised. It'll be for a period of 1 year.
I got you, Bren.
The terms and conditions of probation are going to be all standard terms and conditions of probation. And the following additional provisions. The court's going to order that Ms. Taylor complete a mental health evaluation and any recommended treatment.
All right, we're starting a new thing here on Court Vibes. I will be handing out mental health evaluations and treatment programs for anybody who feels a little weird in chat. All right? We'll have one-on-ones. I will be your therapist. I will help you through it. Mostly I'm going to say rub dirt on it, just so you know.
Substance abuse evaluation and any recommended treatment. Ms. Taylor will be required.
It's almost impossible for me to say how much I love ribs without swearing. I don't know how.
To comply with random monitored substance testing if requested by the probation officer, that she shall not consume any alcohol during her period of probation, and the court is going to enter a prohibition against medical marijuana, finding that it would impair.
Oh, Judge, that one hurt.
Detrimentally impact the purposes of the sentence issued by the court. Court's going to enter a substance abuse assessment of $45. Court is going to enter the minimum fine. I'm going to waive the fine, assess any surcharges or other matters that may be assessed. Ms. Taylor, the court's going to require that you speak with probation. There's a employee here who will speak with you That's really just to set up a time when you can meet with your probation officer. Yes, ma'am.
So, I'm not safe in Colorado Springs. I can't.
Can you imagine the probation officer might go? I feel so bad for them. My heart is breaking for this poor probation officer.
If they want to put me in an institution for injuries, I would say because of their actions, okay? And, I can't take care of myself. The only place I got to stay, other than my son's in Minnesota, he told me I could come and live up there. But where am I supposed to go? I got all my animals, my ESA animals, over there, everything. I never hurt him. I saved his life 8 times.
I saved his life 8 times. I almost believe that. Because so like, out of everybody that I'm living with, except for her, I've saved their lives just with the Heimlich multiple times, just with that one little thing. So I believe that she has saved his life countless times.
I'm trying to hurt him.
I've heard what you've said today. I really have. I understand.
And I really loved him, and I really loved Ashley, and I don't understand.
I understand. I understand that this decision of being able to live where you want is really, really important to you.
Well, it's not what I had to live because I have no place else to go.
I understand that. I understand that too.
Not my own actions, because of his actions.
Yeah. It's just not the issue that this court can decide today.
Well, I thought that I could go home. All these emotional victims, there's all false evidence that I got, I still haven't been able to, talk to him. I had to go in any of my property, in any of my animals, where I'm supposed to go. I live there. I've been there. He's been my boyfriend for 13 years. Everything I own, everything is over there in my animals. They're not being taken care of appropriately. I promise they're not.
Right. I hope you get that worked out.
Well, I'm trying to, but they won't let me.
Court is going to be in recess.
Now that I'm going to use...
What's that mean? So I got...
Hold on. Hold on.
I don't understand.
The probation officer, Mr. Lytle, is at the clerk's office, so thank you.
I'm sorry, I don't mean to be disruptive. I don't understand. I don't understand.
You're not being...
He cut the stream. He cut the stream right there. But I hope you get that worked out. I'm going to use that. Remember at the very beginning of this stream, I said I wanted to say 2 things to my tables? I'm wrong. I want to say that to my tables too. Gee, I hope you get that worked out. No, I can't hear it either. Just give it a second. Actually, this clip is too long anyway, so I'm going to find a different one. I don't know where the sound was on that one. But that one does have a woman with 86 failure to appears. Okay. All right. This one's a little weird.
Please state your full name for the record. Oh, so you're sticky.
Manuel Eduardo Apodaca.
Did you see the video today?
Yeah.
His name really is Apuaka.
You have questions about the rights that were in the video?
No.
Okay. Court finds Mr. Apodaca appears in custody today. The court found probable cause in 26 CR 242153 for the following charges: crimes against at-risk adults or juveniles, a class 6 felony, and third-degree assault, class 1 misdemeanor. Do you see the possible charges for those offenses?
Yeah.
Yes?
Yes.
Okay, thank you very much. So you do wish to address the bond, Ms. Salas?
Yes, Your Honor. I'm not sure if the court remembers Mr. Apodaca. I do believe that Ms. Kovach represented him relatively recently, particularly in 24M4969, which was dismissed by the courts for competency, as well as 24 CR 375 out of Douglas County for the same reasons. And I think I can go on, but there are a few others as well. In speaking to Mr. Apodaca, it does appear that there is some difficulties communicating for those reasons stated earlier. However, Your Honor, I would be asking for a supervised PR bond in this case. I understand that Mr. Apodaca does not want a supervised PR bond.
I don't even want her representing me right now.
But it would be defense's ask for a supervised PR bond or in the alternative, a lower than standard cash surety property bond.
I will not accept a supervised PR bond. I'd rather go back to the competency program. I am pleading not guilty and taking me to trial. So whatever it is to keep me incarcerated, to move the process forward, I will not comply to any supervised PR bond.
Okay.
Okay, at least he saved time. He just saved everybody a whole lot of time.
You will not comply? Okay, that's good to know. Mr. Walsh, position?
Your Honor, a cash surety or property bond is just more applicable in these circumstances, noting a CPAT score of 15, 5 cases in the last 5 years, with a failure to appear in seemingly all of those cases. And then additionally, in the PC affidavit, it seems as if
I know this is a stupid question, but okay, all right. His defense attorney, the defense attorney that's standing right there is appointed, okay? He didn't hire her. That's not his counsel that he hired, okay? And she is doing, all of them or half of them. She's doing all of these people for their initial appearance, okay? All right, you with me so far? Is there okay, when you try to purchase a lawyer, you're going to go hire your own lawyer. You want one that says, I won 90% of my cases, okay? This can't. They don't have records like that for appointed lawyers, right? I won 90% of my cases or anything like that, right? Because it's not fair. This man clearly does not want a PR bond. So she doesn't have a record. I got 80% of my guys PR bonds or whatever. They don't have that, right? For the public defenders.
the defendant allegedly struck the victim here in the face, resulting in a bloody nose. For those reasons, we have concerns for both defendant participation and victim safety.
Okay, the court's considering your circumstances, sir. The court is considering the statements that you've made today, that you would not comply with the PR bond here. Court also really is looking at the probable cause affidavit and has concerns for victim safety. I don't believe PR bond is appropriate. Bond will be $1,000. Cash surety. You have a next hearing date in Division 22, May 20th at 8:30. Good luck to you.
Thank you.
Okay, our next. State your full name for the record.
Lee Allen Hansen.
Did you see the video today?
Yes, I did, Your Honor.
Do you have any questions about the rights that were in the video?
No.
Court finds Mr. Hansen appears in custody today. The court found probable cause in 26 CR 2158 for stalking, a class 5 felony. Do you see the possible penalties for stalking?
I do not at the moment.
Class 5 felony?
It's class 5, 1 to 3 years, 1,000 to 100,000.
Who sang It's My Party? Who sang that? Come on, help me out.
Fine, up to 2 years mandatory.
Oh, okay, I see him now, ma'am. Yes.
And the court is at this time finding that this involves an act of domestic violence. I'll be issuing a mandatory protection order. I show alleged victim is Shannon Wilson. Is she present or expected? Okay. Ms. Wilson, did you wish to address?
That's it, Leslie Gore. When I think of Nan, it reminds me of Leslie Gore.
The court, or are you just observing today?
One person will understand that. Right, Nan?
You might be muted. Okay, I'm not hearing anything. People, have you heard from, have you talked to Ms. Wilson?
Yes, Your Honor. It doesn't seem that Ms. Wilson really has an opinion as to bond. She just noted that the defendant may have access to firearms. and could have mental health issues.
I am here, actually. I couldn't unmute this.
Okay, I'll let you speak in just a moment. Anything additional, Mr.
Oh, and then as far as the protection order, it seems as if she'd prefer it to be fully in place, but she does note that the defendant's rental car is outside her apartment, so there would be a need for a keep the peace order.
Thank you. All right, Ms. Wilson, what did you wish for the court to know, if anything?
Your Honor, when Lee Hansen and I first came into contact in 2023, he led me to believe that he was single and a police officer with the Goodview Police Department. I later learned that he had been terminated from the department. He was not a police officer, and that he was actually married to April Hansen, who he shares a home with in Minnesota. Once I learned the truth of that and things recently that had happened, I had sent a message, told him that he needed to move on. And he continued to contact me, telling me that he loved me and that he sent me even AI generated images of putting pictures with us being together. And one image was with us kissing. He tried to reach out to me through burn phones, texting me from different phone numbers. And then on several occasions, I received texts from who was stating it was his son, who is a Marine in Camp Pendleton in California, which I believe it was Lee. More recently, he even sent me text stating that if I didn't respond, that he was going to drive to my home. I had spoke to an officer last week in the Colorado Springs Police Department. I've been told not to respond to the correspondence, and that things should settle down, hopefully. I followed that instruction, and then Lee did show up to my home at around 4 a.m, pounding on my door. And because of everything that's happened, I don't know what he can do to himself or me. I do believe that he does have mental health issues. I work for Colorado Department of Corrections, and I do crisis assessments for all state prisons remotely.
So she works for the Colorado Department of Corrections. He is a police officer who is married to someone else.
For offenders, and from what I've seen in my experience, is I really believe he struggles with mental health issues, and he does need mental health help.
So it looks like I appreciate your statements. Mr. Hansen, at this time, I'm ordering that you have no contact with this victim. That means any type of contact. That means electronic contact as well.
I totally understand.
I'm also ordering that you, vacating the family home is not at issue here, but I am ordering complete no contact with this victim. Do you understand?
I totally understand that, ma'am, and I'll sign it 5 times over.
Okay. Court finds that Mr. Hansen acknowledges this protection order. Court is making a finding of threat of force. Within 24 hours of your release from custody, you are to relinquish all firearms in your possession or control. You are to complete a firearms affidavit regarding violent assaults.
Judge, in speaking to Ms. Hansen, Mr. Hansen, it appears as though I do not see any criminal history in Colorado, and noting that he does not live here, I do recognize that that's all I can see. But in speaking to him, he has represented to me that he does not have any criminal history where he resides either. Pretrial services is noting a CPAT score of 3 in this case. I do recognize the alleged victim's statements and understand her concerns in this case. However, he does currently work. He's a security training manager. He'd be at jeopardy of losing his job if he were to remain in custody. He's worked there for approximately 40 years. He does live with and take care of his wife, who is disabled and needs additional care. 40 years, Your Honor, not 40. Eileen Sinclair. He has transportation to court, access to a phone. He has also represented to me that he is former law enforcement. He does understand protection orders and would be able to certainly abide by those. He does have some medical concerns where he does take medication. I'm unsure of the status of that, but knowing what I do about PJC, it may be hard for him to receive that medication. He's also a former Marine and active Army Marine veteran. For those reasons, Judge, I would be asking for a lower than standard cash surety property bond or the alternative, a supervised PR bond in this case. Thank you.
Thank you. I do want to make another modification to the protection order. I'm ordering not only that you have no contact in any form, I'm also ordering that you not go to any location where you think she might be located.
That's understandable, Your Honor.
Okay. So I'm making that addition. Mr. Walsh, on the argument on bond.
Your Honor, before I address bond, I believe we have a non-party to the case. I believe her to be the current wife of Mr. Hansen here. I'm not sure if that's best addressed here.
Okay. So since you are not a party to the case, who is that person? I'm not going to have you address the court today, but you're always welcome to come to any hearing because they are open hearings, okay? All right. Thank you. And then on bond?
And then as far as bond, Your Honor, we think elevated cash surety or property bond is just more sensible here. The allegations in the PC affidavit are worrisome. The defendant allegedly showed up at the victim's residence here making statements along the lines of, if I can't have her, nobody will. There was a possibility of the defendant allegedly being armed, although that's admittedly unclear. The defendant was also reaching out to, I believe, the current fiance of the victim, and the communications here were persistent with over 80 texts through that time period, which raises significant victim safety concerns.
Thank you. The court's considering all of the arguments, statements from alleged victim at this point. I've also reviewed the probable cause affidavit. I'm extremely concerned for this victim's safety. Because of that, I don't believe the PR bond is appropriate here. However, I don't see a strong, compelling reason at this point to order an elevated bond, given the low CPAT score. And what seems to be a little bit of it's a little bit unclear to the court regarding the firearms allegations, but I do take that very seriously. And so I am setting a cash surety bond. It will be in the amount of $6,000. You have a next hearing date of May 26th at 8:30 in Division 20. Good luck to you, sir.
Thank you, Judge.
No keep the peace. Thank you. Harrison?
One of those two things is.
All right, if you thought that guy was scary, it's nothing compared to this guy. This guy, holy crap.
In place prior to Mr. Schimpf being released. I do think that obviously through the VA, the inpatient treatment program has a lot of benefits to Mr. Schimpf. I know that this case is, a class, is a kidnapping charge. Again, the allegation being that Mr. Schimpf lifted up a woman outside of a bar and, ran a distance with her. This is not a situation where, he grabbed someone and put them in a car and drove them somewhere. I'm not saying it's not a serious allegation. It is obviously a serious charge. But in terms of, obviously, I think kidnapping can mean a lot of things based upon the language of the statute. So I think it's important to keep the specific allegations in this case in mind. I know that Mr. Schimpf was on probation for another case. We would be asking, obviously, that the court modify both bonds to mirror each other.
Other case was also kidnapping. Different victim.
So that way when Mr. Schimpf can go enter into the treatment program. He does obviously still have contact with the VA and was set up with them and meeting with them regularly.
I heard veteran Marine.
Which is, I think, how we ended up in this situation with him getting the inpatient treatment. I do think it's appropriate. I think, obviously, the allegations in this case could suggest, and based upon what the probation officer said in the past, be related to alcohol or substance use, and so inpatient treatment being able to get the root of that issue. And so I think that Mr. Schimpf has the ability to successfully complete that program, I do think that that would prevent him from, being back before the court in the future. And so I would be asking the court modify the bond to a treatment bond accordingly.
Thank you. Is your internet slow?
Yes.
Okay, I'm just having trouble getting to different screens. All right. Go ahead, Ms. Lawrence.
Your Honor, in 25 CR 961, we've made more than sufficient efforts to VRA that case. In 26 CR 302, Ms. Poole had said, I believe that it would be a poor decision on the court system to allow him to go to a facility that's not locked. Repeated behavior has shown that has a blatant disregard for others as well as a lack of personal responsibility. I'm all for somebody receiving treatment to better themselves, but under a locked-in patient service would be ideal. In 25 CR 961, Mr. Schimpf had pled to assault causing serious bodily injuries, a class 4 felony for stabbing his girlfriend's son. He had just started probation December 5th and now has picked up 2 new cases, which happened in very close time to each other. This new case, 26 CR 302, date of incident was March 21st. He had approached Ms. Poole, who was a stranger, outside of a bar, told her that she was hot and she was coming with him now, and picked her up and started running. She didn't know that he didn't have a car to throw her in and drive her away. I can't imagine how terrifying this was for her. And then he tripped and fell, causing injuries to her, and then tried to follow her back into the bar before finally walking away. And that same morning, he picked up 26M 5056. He had approached 2 strange women outside of a hotel. I believe it was possibly the hotel that he was staying at the time. He grabbed one of them by the hand, interlacing their fingers, and told her to pretend to be his girlfriend. Grabbed her forcibly on the arm and walked her down the side of a vehicle, telling her to keep doing what she was doing, and asked for her room number. She yelled for help when she saw a hotel employee. She actually delayed reporting until she saw him approach a group of juveniles, and she was concerned that he would do something to them. Law enforcement did observe bruising on her arm from where he had grabbed her. So now we have a very violent attack on his ex-girlfriend's son. A stabbing is extremely serious. We have extremely concerning behaviors toward women as well now. Only on probation for a couple months before picking up 2 new cases. His CPAT score is 15. He's a category 4 now with 3 prior felonies, 1 misdemeanor conviction, 6 lifetime FTAs, 2 in the last 5 years. I would note he was in custody the entire time that 25 CR 961 was pending. And I don't believe that in any way, shape, or form that a PR bond is appropriate, especially to go to what I would assume is probably not a locked facility out of the county.
Thank you. Anything else, Ms. Watkins?
So, Your Honor, it does indicate on the letter that it's structural rehabilitation program, that there is substance use accountability in UAs and breathalyzers upon admission, also ongoing weekly and random substance screenings, that the veterans participate in daily programming, individual and group therapy, case management, and recovery-focused intervention. It's a clinically supervised setting. It is in Jefferson County. I understand that. I don't believe that
So, Judge, it's supervised. Don't worry about it.
we have a similar veterans opportunity in Grand Junction. And so I think, otherwise that would have been explored. I do understand that the prior case was serious. We did receive a stipulated probation offer in that case. So I do think that that does cut a bit against that argument, since that was given by the same DA. I do also think that individual was quickly, the alleged victim in that case was quickly arrested and then taken out of state for an outstanding warrant, and then was not able to be contacted again. So I do think that this, with additional conditions, I think the court could certainly mitigate any concerns related to community safety. Obviously, is required if it's a condition of the bond. which we're fine with, obviously, and frankly, we're requesting that be a condition of the bond, that the VA could update the court if anything were to go awry or Mr. Schimpf were to leave the program. Granted, I don't think that that's a likely outcome, given the work that, I think he had independently done prior to being incarcerated to get into the program, and had specially spoken with the VA in order to get into the program.
Ms. Lawrence?
Your Honor, I would just note for that prior case, the victim having his own case in New Mexico has absolutely nothing to do with this. The probation.
Absolutely right. That was unbelievable that she even just said that.
Sentence that was offered was strictly because we could not get a hold of that young man. I had law enforcement going to his house, knocking on his door, leaving cards, and we did literally anything and everything we could think of to try to contact him. People were in the house. They refused to open the door. So that probation.
They're saints, huh? So this is why. This is why. When women are asked, would you rather be trapped in the jungle with a man or a bear? We struggle. We mostly pick bear. We're going to pick bear most of the time.
Sentence more reflects the fact that we couldn't find him or contact him, not the fact that I didn't believe that Mr. Schimpf was a community safety concern. And albeit at the end of the day, he pled to a class 4 felony for assault causing serious bodily injury.
Understood. And the court's not going to relitigate that case, and the court recognizes and remembers why this all occurred. The court's concern here is that there's just, from my perspective, there's just too much risk here with regard to community safety, given the present circumstances that we have when you take into account all of these factors that have been put in front of me. It looks like a person who is likely to commit offenses and violent offenses, or at least offenses that will cause victimization if I let him out of custody because of the state that he's in. The court certainly seriously considered this, because I think this is a great opportunity for this defendant to get into this place, but the risk is too much, and the court is not going to take that risk in this circumstance. So the bonds remain the same. Counsel, when do you want to come back?
We can come back tomorrow, 22 hours from now, please. Whew. All right, guys, thanks for coming out. I appreciate it. Tomorrow's Wednesday, so we get 2 streams tomorrow. Yep. But we had a good stream, and I hope everybody behaves. Don't go grabbing any women on the street, please. Just try not to. If you feel the urge, go color something or knit. I hear knitting works, right? Lori, loved seeing you. But just rest and relax, okay? All right, guys, have a great day. See ya. Thank you. Crochet, yeah. And happy birthday, Kelly. Kelly, happy birthday.
I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her style is classy. She a guarantee.